Zimbabwe Exemption permit holders have 3 months left before the extension expires. Government had announced that it would terminate the ZEP on 30th June 2023. Almost 180,000 permit holders will be affected. Lobby groups have taken the Home Affairs Department to court to challenge this decision. The Helen Suzman Foundation is part of the court challenge, and Director Nicole Fritz joins me now to chat through this conversation. What motivated you? Well, Nicole, I suppose the first thing is to say very good morning. Thanks for joining us.
Good morning. Thanks for having me on the show.
So what has motivated this challenge or this defence of the Zimbabwe Exemption permit holders?
Well, I think it's recognising the tremendous hardship that these 178,000 Zimbabwe Exemption permits are facing. They're being put to a really terrible choice given the termination of the permits. They are either going to have to return to Zimbabwe, a country that is virtually unchanged from the country they fled now over a decade ago, and they've obviously built homes, lives, families here in South Africa, or they will have to become undocumented migrants here in South Africa with all the vulnerability that attaches to that. But we also take the position that the manner in which this decision was made is prejudicial not only, firstly, to Zimbabwe Exemption permit holders, but to all South Africans, that we don't want government action, decisions taken, without there being proper consultation, fair process followed, and so that government decision makers are fully cognizant of the consequences of their decisions before they make them.
Let's go back to, I think, 2009, is it, when they were first issued?
Exactly.
Was it a consultative process then?
So to some extent, there had been a consultative process. There were thousands of Zimbabweans streaming into South Africa following the political turmoil, the violence there. South African government decision makers were seized with that process. And there actually was an extensive policy-making process which led to the first iteration of this special dispensation program. But I should also say that when you grant rights to individuals, there is less of a requirement, certainly in terms of our legal requirements, our legal standards. There's less of that requirement that you undertake this consultation process than when you remove rights, right? And what our Constitution protects is that if you are going to remove rights from individuals, that there be a consultation process, a fair process followed prior to the removal of such rights. Now,
before we talk to the case that will be in court in a few days' time, let's talk about the implications. I mean, we speak of 178,000 Zimbabwe Exemption permit holders, but it's not just 178,000. They have children,
exactly.
They have families.
Exactly.
What is that sum total number, if you were to estimate, and the overall impact that would have on because there is an ecosystem. These people have loans, they have mortgages, etc. They have jobs, they're accommodated, and so on.
Exactly. So I don't know the exact number of the children that have been born, but there have been large numbers of children born to the 178,000 Zimbabwe Exemption permit holders, right? And they know no other home but South Africa. And so to require them essentially to return to Zimbabwe or to be rendered undocumented is to impose enormous consequences, detrimental consequences on their education, on their access to social services here. But as you say, it's not just the children or the Zimbabwe Exemption permit holders themselves. This decision is, we maintain, and has been taken without consideration of the ecosystem, the communities in which they are involved. So it's, as you say, persons who hold jobs but are part of communities who are running business and have created jobs themselves. And so without a proper process of consultation, you don't know exactly what the consequences are going to be, not only to the Zimbabwe Exemption permit holders themselves, but the ecosystems, the communities in which they live, the detrimental consequences to them by simply excising them from the body politic of South Africa, as it were.
Now, you've taken the Home Affairs to court, and all of that will be happening in the next few days. I think between the 12th and 14th of April, if I'm not mistaken. Let's talk about your argument. What is it that you are saying to the High Court?
So, as I've already indicated, we're not saying that the Zimbabwe Exemption permits have to be continued in perpetuity. What we are saying is that if the minister is going to take a decision to terminate these permits, where they have essentially existed for now over a decade, for 13 years, to be correct, that you must do so having consulted, not only with the Zimbabwe Exemption permit holders, although primarily with the Zimbabwe Exemption permit holders, because they face the sharp end of such a decision, but with the general South African public prior to making a decision. So we're saying that there is a fair process that needs to be followed prior to making this decision. Absent such a fair process, we're saying if the court, upholds our argument and says, yes, you've shown to the court that there was not a fair process, then the decision to terminate must be held to be unlawful and invalid. It must be sent back. It must be remitted to the minister, and that the minister is obviously entitled to make a new decision, but he must do so having followed this fair process, a process that includes, requisite notification, fair consultation, and with proper consideration of the particularly vulnerable segments of those within this group, most notably children.
Now, the extension over the last 24 months, I think, has happened twice.
So there was the initial decision was that it was going to come to an end at the end of 2021, and that was basically given with a month's notice. It was then held that there would be a 12-month grace period within which supposedly permit holders might regularize their stay. It was then determined that actually there weren't legal mechanisms to provide such a grace period. So the exemptions permits were actually extended for a 12-month period, and then they've been subsequently extended for another 6 months. Because, in fact, this process of seeking waivers and exemptions, allowing individuals to try and secure waivers and exemptions and apply for visas, and there's a very small number that might be eligible for such visas, that there hadn't been sufficient time, that they weren't being processed, that there was such backlog within the Department of Home Affairs that it had to be extended for another 6 months. So in total, it's been an extension of 18 months.
So 18 months, the Helen Suzman Foundation and other parties suddenly appear and start arguing about the unlawful, not so much the extension, but the termination of the exemption permit. But you've had, one school of thought said you've had 18 months to stop these negotiations, have these conversations. At the first time of asking, there seemed to be no reaction. Why? Why wasn't this put before the courts any earlier?
No, it was. I mean, at the time that the termination was first announced, we launched our application, as did the other parties. So this court action has been in place since the termination was first announced. And we have really battled to try and secure the earliest possible court date, because we fully appreciate the chaos that is going to, and the uncertainty that so many Zimbabwean exemption permit holders, we recognize that it would be far better for them to know the outcome of this court case earlier so that they could plan for their lives accordingly. But this was the first possible court date that we were able to obtain.
Now, those that are in support of the termination of these permits, many South Africans, argue that the service delivery system is fully stretched. There isn't enough medication in the hospitals to go around, and part of this is because you have 180,000, call it, Zimbabwe exemption permit holders that are in the country now making use of these services. How do you respond to that?
So, look, I mean, the first thing that we would say is that we fully recognize the enormous hardships that South Africans are facing, right? And it seems, and we know it seems difficult to swallow, this idea that one should be generous and hospitable to those who are not South African born. But our problems are not such that removal of 178,000 individuals who have lived here for over a decade is going to cure those problems. If it does, then the department and the minister need to show that, right? They need to, in order to support their decisions, say, these are the studies we've undertaken. Like, by removing these 178,000 individuals, we can, in fact, cure the unemployment crisis, or we can relieve it to a significant extent. And we can do that similarly in respect of the strains that have been felt in our public health system. But nobody's making that credible argument, right? That removing 178,000 is going to cure or have a significant positive impact on the stresses that we face in terms of our social delivery. And again, we don't know, right, because we haven't undertaken the studies. To what extent are those 178,000 individuals, in fact, of enormous benefit to South Africans? How many are teaching our children? How many are creating jobs? How many are paying, paying rents to local South Africans and uplifting our economy? We don't have those studies to support the decision.
Nicole, you keep speaking about the absence of information, which, in my perspective, would be vital to this argument, right? So you're almost suggesting that you're going into battle and you're ill-equipped for that battle because there is this information about the implications of, transplanting 180,000 people plus back to their country without necessarily having done the due diligence to establish the very extent of what this would mean. And surely that information could make a difference when you go to court in a few days.
Yeah, but we're not the decision makers, right? The obligation rests on the decision makers, the government that is making the decision essentially to expel these individuals. To say we're making this decision, recognizing that it is going to have significant hardship for those individuals.
The idea surely is to go with as much armory as possible into court. Now, much of what you've said suggests that you are going there without information that potentially could sway the thinking of a...
Our argument is essentially that, as I said, and this applies to all South Africans, that government decision-making, where decisions are taken that remove rights, that there has to be a fair process of consultation, that it is that consultative process that is going to allow for the gathering of that information. Without that information, without that consultation process, you can't make a decision understanding the full consequences thereof. So that is our argument. And the fact is that we're saying engage in the consultative process. You will then have the information. And it may be that the minister and the department decide that the Zimbabwe exemption permit must be terminated. But they do so having full sight of the consequences and what the implications are, not only for the Zimbabwe exemption permit holders and their children, but for the fuller community, South Africans generally too.
Now, if the court comes back and says a consultative process does need to take place, paint a picture for us of what that process will look like.
We're not, our country, our law, our processes are not unfamiliar with consultative processes. And it can take various forms. It might be a notice and comment process. It might be gathering communities together and asking them, in person to explain what the consequences are. What does it mean as a Zimbabwe exemption permit holder, for instance, who has a chronic illness? What does that mean for them to be returned to Zimbabwe without a job, having to, without a home, in some cases without their families because they might be married to South Africans? How do you access healthcare there without the job when we know that the healthcare system in Zimbabwe is almost entirely collapsed? So,
Nicole, I have a minute to go before we have to wrap up.
Sure.
But come April 15th and the decision is in your favor, what will that decision look like for you?
So we're not going to, let me just be clear, we won't get a decision on April 15th. The court case is running from April 11th to the April 14th. The court will then go and consider these arguments and will come down. We certainly hope that the court is well aware that it is of absolute importance that a decision be handed down as soon as possible. A decision in our favor means that the decision is remitted back to the minister. And the minister, as I said, is entirely and fairly able to make a decision that terminates the Zimbabwe exemption permits, provided he has engaged in a consultative and fair process, most principally with the Zimbabwe exemption permit holders themselves.
Nicole Fritz, appreciate your time and wish you all the best with your case.
Thank you. Thank you.
Nicole Fritz is the director for Helen Suzman Foundation and speaking to us about the Zimbabwe exemption permits and the court case that they've put through, which is being heard between the 11th and 14th of April.